Okay, so this evening we're going to be covering Chapter 7. We have two more chapters to cover. We have Chapter 8 and Chapter 9. Tonight we're going to be focusing on the promulgated addendas and the other forms that are going to be involved in the contract process. Now, I do want to make certain that everybody understands this, that when dealing with the promulgated addenda and other forms, it is going to be imperative that you understand that the previous class that we talked about, what we went through and discussed and all, and was going to basically be the contract. So what happens in this particular situation is that in the contract, when dealing with it, there are going to be a total of 6 contracts. However, like I said in the previous class, 2 of those contracts may not actually be used. And it's not the fact that it's not done correctly or whatever. It's just the fact of the matter is that builders in most situations, they end up, they turn around and they primarily use their own forms. So while there is a total of 6 contracts, in real life, you're probably only going to utilize about 4 of those. So we went through the previous class, we talked about those. Now this class, we're actually going to go in and we're going to talk about the other items that can be added to those contracts. So really, all you need to know is technically in real life 4 contracts. And as you do it over and over and over, that's why I tell a lot of people is that if you've done something repetitively 5 times in a row, you're most likely going to know how to fill their contract out, okay? You're going to kind of see the things and the reasoning and stuff like that. And that's kind of why when I train agents, when they come on with me, I do take a bigger split in the beginning for their first 5, because normally after their first 5, they don't need me. It's kind of just, I've got them down, I don't need you anymore. I'll check things for them, but ultimately, there's not a big demand to use me after that point. And that's the objective. The objective is not to end up having agents where they are consistently needing their broker, okay? So tonight, what we're going to be talking about is basically everything else. So there's going to be a lot of different things. We may look at some forms. We may not look at some forms. Again, we're going to talk about things, but like I said, we're just going to take this and play this by ear. Now, one thing I want to let you know is because the majority of my people tonight are going to be online. Reason being is we had a meeting here at the office, and I primarily just rather had everybody at home so that I could end up having my meeting for my agents here today. So some of my agents, especially 2 of them here tonight, are probably extremely tired of listening to Justin talk tonight. Yeah. Because they've heard me talk for 8 hours straight today. So they are probably not going to show up tomorrow. But in the situation is that we're going to we want to get through these. So what we're going to talk about is first, let's look at our learning objectives for this evening. Again, we want to describe the proper use of the addendum for sale of other property by buyer. We also want to describe the proper use for the addendum for backup contract. We also want to describe the proper use for the addendum for reservation of oil, gas, and minerals. We also want to we're going to identify which form of buyers should use to reserve the right to terminate a contract, and describe how mutual termination of a contract should be handled. We also describe the proper use of the addendum for property located seaward of the Gulf Intracoastal Waterway and the addendum for coastal area property. We will also describe the proper use of the addendum for property subject to mandatory membership in a HOA. We'll also describe the proper use of a short sale addendum. We'll further describe the proper use for a non-contract forms, such as the promulgated resale certificate, consumer information form, and the information about brokerage services. Further, we will describe the proper use of the remaining optional forms, which are going to be the non-realty items addendum and the Texas Real Estate Consumer Notice concerning hazards and deficiencies. Okay, so as you can tell this evening, we've got a lot to end up covering this evening. So with that being said, we're going to jump into this. But I'm going to tell everybody here, remember, you don't have to know everything verbatim. So don't freak out on me tonight when we're going through contracts, or not contracts, but the addendums, going, oh my God, what do I do? All you need to know is you just need to end up knowing what the form is, what it's utilized for. Okay? Pretty simple here. Okay? So, in regards to the addendum for sale of other property by a buyer, it basically provides a contingency for the buyer in case the buyer cannot sell their property. And in this contract, it is time is of the essence. So the seller may continue to show the property, and if the seller accepts the offer, they can require the buyer to end up waiving the contingency. Okay? So with that being said, let me kind of explain this. I'm going to try to pull a form up here real quick. Okay? Pull one up over here. We're going to talk about it. Right here. So this addendum, if a client, now remember, like we said, there are only total of 6 contracts, total, okay? But these addendums can be added into the contract as a whole, okay? So everything we're talking about tonight can be added into the contract, okay? So one of the key things that you will notice here is you would normally, in this situation, this is what the form looks like, as you see on your screen. That's what the form looks like. What normally would end up happening is, say that Mr. Colton is purchasing Travis's house, okay? And Travis's house is 123 Main Street in Bryan, Texas, 77802, okay? Now, Mr. Travis and Mr. Colton will also have not just this addendum, but they would have a full contract, okay? So this form is not sent independently and then a contract. All of this is sent at one time, okay? So a lot of people will say, well, do I send this at a certain time or whatever? No, you're sending everything, the contract, all addendums at one time, okay? So what happens is Colton tells Mr. Travis in his contract, he includes a addendum for sale of other property. So he's going to include the property that he's buying here, the one that he's purchasing. But here, he's going to say that he's selling his house at 456 Main Street in College Station, Texas, 77845. Okay? So he needs to sell his property at 456 Main Street in order for him to buy Travis's at 123 Main Street, okay? However, in the contract, whatever you put as your closing date, needs to be the date entered on this line. So if you're going to be closing, say, February, if I can spell correctly, February 1st, 2021, and that's your closing date, then that closing date needs to match the date that's showing here, okay? They need to basically be consistent with each other. Now, down here, the normal standard is the 3rd day. And what this means is, so A identifies the property, okay? And it identifies the contingency. And if you see here, as it is in parentheses, that is the contingency deadline, okay? So Mr. Colton has to sell his house no later than February 1st, 2021, okay? If he doesn't, then the contract terminates automatically and the earnest money is refunded to the buyer, okay? Now, down here on B, this is a little different. So this is where you got to explain this to your clients, okay? Mr. Colton goes over, and Mr. Colton ends up, he says, I want to buy your property, Mr. Travis. Mr. Travis and them come to an agreement, they sign their contract. Everybody's happy. Colton's happy, Travis is happy, everybody's happy-go-lucky, okay? However, what happens is Mr. Travis is still marketing the property. Okay, because Travis wants to see, can I possibly maybe get a better offer? Okay, well, what happens is Mr. Grossman comes into the picture, and Mr. Grossman contacts Mr. Travis and says, Mr. Travis, I would love to purchase your property, and I want to I will pay cash and close in 10 days. Okay, Mr. Colton is only going to be able to close on February 1st, but Mr. Stephan, in this hypothetical, can close, say, by Friday. Even though we said 10 days, let's say it was by Friday. Okay? In that situation is, guess what? Mr. Grossman will probably be the one that Mr. Travis wants to jump on, simply because the fact is, he gets his money quicker. Okay? And there's no financing or any of that crap to deal with. He just goes on and gets the cash and walks away. Okay? So under B, if the seller, if Mr. Travis in this situation, if he accepts a written offer to sell the property, the seller shall notify the buyer of such acceptance. So number one, Mr. Travis has to notify Colton and say, I have accepted an offer that I like, and that the seller, Mr. Travis, requires Colton, the buyer, to waive the contingency. So if Mr. Travis wants to take Mr. Grossman's offer, it does not automatically mean that Colton is out of the contract. Okay? It just means that Mr. Travis is telling Mr. Colton, you need to waive your contingency so that I can end up, either you're going to buy my house without the contingency, or you're going to get out of this contract and let me go use Mr. Grossman's. Okay? So it's saying that the buyer must waive the contingency on or before the 3rd day after the seller's notice to the buyer. So if Mr. Travis notifies Mr. Colton that he needs to end up, that Mr. Colton wants to go over, and you, Travis, you notify Colton and say, Colton, I got an all-cash offer, they're closing Friday, are you going to close with me? And that particular situation is, Travis has notified Mr. Colton, and if Mr. Colton does not remove it by the 3rd day, then, like it says here, the buyer must waive the contingency on or before the 3rd day after the seller's notice to buyer, otherwise the contract terminates automatically and the earnest money is refunded to the buyer. So if your client just says, well, I'm just going to pout and not do anything, well, it's still going to terminate. You might as well just let it be and move on. Okay? Now, real quick, Mr. Grossman, do you mind coming up for a second, please, sir? Mr. Grossman, now you have a little experience with this situation here. What happens with B? What is a problem with B if you're representing the buyer? What was in your situation? What ended up happening in your transaction? What happened to your buyer? Was they happy with this, or what happened?
No, because somebody came in with a full price cash offer and the other people accepted.
And so what was how did your client feel? Were they happy, or how did your client feel?
They were very mad.
They were very mad.
Yeah.
And in that situation, what can you do about it? There's nothing you can do. Thank you, sir. So in that situation, like I said, was poor Mr. Grossman in this situation. He ended up, his client called and was extremely, extremely upset. Okay? But that's part of dealing with this. Do you see why it is imperative that you notify your client that when they complete this form, there is the possibility that the seller could back out of the contract? Because see, here's the thing, just like we talked in law of contracts class, we said that if all the elements are met, the contract is what? It's valid. So if it's valid, how in the world can you back out of a contract that's valid? Well, that's what this contingency is. That's what allows them to get out. You're giving the seller a way out. So a lot of buyers will say, well, then here, this is what we'll do. We just won't include this form. We just won't include it. Then I don't have no contingency issue. That's how we'll get them. Well, do you think that's a wise move, Mr. Travis? Why do you say no to that, sir?
Well, because if you don't have a contingency,
If you can't sell your house by closing date, what happens?
you're in breach of contract because you don't have the funds for it.
That's right. You are in breach. And because you breached contract, now you're in trouble. So while a lot of people say, well, I just won't put that in there. Well, you go right ahead, just don't put it in there. But if your client doesn't sell their house, guess what? Your client could be sued and be still forced to purchase a house when they can't get funds. Okay? So very important in that situation. Now, if, for example, say that Travis notified Colton, and Colton said, yeah, I'll remove my contingency. Mr. Travis, remember you asked me the other day, well, what is this other time to put earnest money down? We talked about that. Well, looky right here at C. This is where C comes in. If Mr. Colton does decide, I'm just going to waive contingency, I'm going to get rid of this, Mr. Colton would have to put down another $500. He would place this $500 down, and Mr. Colton at that point has now waived this contingency. Okay, so in that particular situation, he would have to put his additional $500 down to what he already has for earnest, and now this contingency has been waived, which means now, Mr. Travis, you cannot accept Mr. Steffen's offer. You see what I'm saying? Because Mr. Colton still has first right. Okay, but again, very rare do I recommend you ever to remove this contingency, ever. I'd rather have an upset client lose a house than end up being stuck in a contract that they may or may not be able to close on a house. Okay, so again, that is going to end up being the very first one. Okay, now in regards to the next one, the question always comes in is a backup. Now this one's going to be kind of interesting. I will say this to say the least on this is, so what happens? Okay, and this is a personal preference. I want y'all to understand this is a personal preference. But let's say this. Let's say in this situation. So I have a client, we say, and I go over, and my client, his name we'll say is, say that my client's name is Mr. Jacob. Okay, so I represent Mr. Jacob. And I go in and I say, you know, Mr. Jacob, let's go look at some properties. Let's go look. So we go look at some properties. And Mr. Jacob in this situation goes in and he finds a house that he likes. Found the perfect house for himself and his family, and he wants that house. That's what he wants. So Mr. Jacob says, Justin, I want you to put a contract in. I said, yes, sir, I'll get on it. Draft up the contract. I send the contract off. So once I send the contract off, what ends up happening in that situation is that once I send it to, say, Mr. Stahl, say that you're the listing agent, I send that contract over to you, Mr. Stahl, and you call me and say, oh, Justin, man, I'm so sorry. Mr. Grossman finally actually beat you to one, and we accepted his contract. And so we apologize, but unfortunately, we're going with Mr. Grossman's. So I call Mr. Jacob, and I tell Mr. Jacob, say, Mr. Jacob, I'm sorry to inform you, but they decided to go with another contract. So Mr. Jacob tells me, well, Justin, that was my forever home. I need that home. And I say, well, Mr. Jacob, you know, we could submit a backup contract. Okay. And Mr. Jacob says, okay, well, that would be wonderful. Let's do that. And I say, okay. Before we do that, Mr. Jacob, I need to explain something to you. This is where agents make mistakes all the time. What happens is if I send a backup contract to Mr. Travis, okay, Mr. Travis already has a contract, say, with Mr. Grossman. Let's just shoot 60 days. So they had a closing date. It's a VA loan in 60 days, okay? So Mr. Travis has a contract, VA loan, 60-day close, and I go ahead and I submit a backup contract to Mr. Stahl on this house. Mr. Jacob still has to treat that contract just like it was a real contract, okay? So Mr. Jacob goes over. We still got to treat that contract just like it's a real one. So once I send it over, everybody signs the backup paperwork. I still have to get the money for earnest money for Mr. Jacob. I still got to get all of the stuff. I got to do the same processes. But here's the only thing, okay? Mr. Jacob's contract is now enforced, but it will not fully calculate until Mr. Grossman's contract falls apart. So say Mr. Grossman goes through the process, options goes on, Auction goes on, the inspection goes fine, appraisal goes fine, everything's moving along, and it's 45 days. Okay, and within that 45 days, Mr. Jacob finds another house. He found another house that he loves. And he says, Mr. Justin, I want to put an offer in. I say, well, Mr. Jacob, you understand, sir, that you're currently under contract on this other home. Well, I'm not in love with that one anymore. Well, Mr. Jacob, you're under contract. Well, just get rid of that one. Okay? You can't just get rid of it. You're under contract. So what happens is Mr. Jacob's like, Justin, it's already passed appraisals. It's going to fund. It's no big deal. Let's go and put an offer in on this. And against my expertise, I tell Mr. Jacob, I don't recommend it. I don't recommend it. And he still wants me to submit it. So I submit a contract on this other house, and this other house is represented by Keith, and Mr. Keith accepts it. Mr. Keith goes in, they accept the contract. So I call Mr. Jacob and say, well, Mr. Jacob, congratulations. The contract that we put on this other house, Mr. Keith called, we are under contract, sir. Congratulations. Mr. Jacob is happy as can be. Now guess what happens? Something happens in the financing with Mr. Steffens, and Mr. Steffens' contract falls apart. Now guess what happens? What happens at that point? If Mr. Steffens' contract fell apart, who's in contract? Now Mr. Jacob's in contract to purchase that property with Travis, but he's also now under contract to purchase with Mr. Keith. He is now in 2 contracts, and he is now in a situation where he has to buy 2 homes. And in that situation, he is most likely going to breach one of those contracts. Okay? So it is imperative as a real estate agent, it is imperative in this situation, like I tell people, that you understand when dealing with these particular situations, that you explain to your client that while a backup contract can be beneficial, and it can, and sometimes, if it's a hot market, you want to put a backup contract in. You don't want to put a backup contract in if it's just a normal market. There's not much competition. There's a lot of inventory. Not a wise idea. Okay? Clients will always think they found their forever home until they do what? They start looking some more. And then they find another one. And then they find another one. And then they find another one. Okay? So the thing is addendum for backup contract, like it says, is the contingency upon termination of the first contract. However, time is of the essence. Neither party is required to perform during the contingency period, although earnest money and any option fee must be paid if provided in the contract. You got to pay that up front. So what ends up happening here is you're putting your client in a catch-22, and it's not something that I advise. Now, I will tell you, in my office, if you're going to use a backup contract, I will be involved, especially during your training. I will be involved on any backups, and I'll explain the processes and talk to your clients and all. But in most situations, it's not recommended. But if you're in a hot market, when I was, 2011 and 2012 here, guys and gals, you put a listing on the market and you'd have like 10 people lined up at the door already, okay? When it's something like that, yes, a backup contract is very key, okay? Very key. But if you're in a situation that a house has been sitting on the market 400 and some odd days, you don't need to put a backup contract. It's not worth it, okay? Very important there. So, going to that, we'll pop this over here. Again, you always put in the property, 123 Main Street. This is the address of the property, okay? So you put it in here, 77802. And as you notice here, the backup contract is contingent on the termination of a previous contract, the first contract that is dated, and of course you would enter the date. So we would say January 12th, 2021, okay? For the sale of property, blah, 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 is the first contract. And again, this is the dated part in regards to when it was accepted. If the first contract does not terminate on or before, this is going to end up being the closing date. So you enter in the closing date. Say we were doing February 12th, 2021. I'm going to place that in. Then the earnest money is sent back. But again, in this situation, these are your terms in regards to the contract, okay? Again, an amendment or modification of the first contract will not terminate the first contract. So just because I do an amendment does not ultimately terminate the contract. Again, it is in strict compliance with all times and performances that everything is followed by key. That's where you get your time is of the essence. Okay? Again, good form, not something that I recommend. Okay? Not by any means, unless it is a particular situation. Like I said, that'd be something that me and you would sit down and talk about with your clients. Now, the next one that we're going to talk about is the addendum for reservation of oil, gas, and other minerals. Okay? So in this particular situation, this form, again, you've got to be very careful with this form. Okay, and the reason I'm saying it, we'll talk about it real quick here. So it is the addendum that deals with fundamental issues of ownership of oil, gas, and other minerals, and the waiver of surface rights, and warns all parties to seek legal counsel before signing the contract. Now, here's the key thing, and I tell people this all the time. If a client is wanting to receive or keep mineral rights, this is another one of those areas that you need to have your client seek legal counsel. Okay? Bless you. And it needs to be legal counsel of their choosing, not your choosing. Okay? They need to seek legal counsel. They need to talk to counsel. You need to be present in that meeting. And what ends up happening is it's going to discuss the rights when it comes down to the ownership or the reservation of oil, gas, and minerals. Because here's the thing, and this is extremely important. If you screw something up in the contract and you don't check it correctly, you can literally, your party, if they're wanting to reserve the minerals, may end up actually losing the minerals because you didn't do it correctly. Okay? And let me tell you, you lose somebody's minerals, think they're going to be happy with you, Travis? No, not at all. Not at all. Okay? So, the reason you seek legal counsel in this particular situation is because, as you notice, this is only a one-sheet form. It's a one-sheet form. Okay? The problem with that is, if you are seeking any minerals, you need to be aware that everything is covered. And normally a one-sheet piece of paper is not going to be enough to make certain that you're keeping all of your minerals. Okay? Again, read the notice up here. For use only if the seller reserves all or a portion of their mineral estate. If they are going to do any type of situation, I've had people before that when you're dealing with minerals, you're not dealing with a small little subdivision. You're not dealing with a little lot, okay? You're dealing with land that may be 100 plus acres. And if there's 100 plus acres, guess what? It probably is not owned by one individual. It's probably a parent had it or a grandparent had it, and they have passed away, and it has now been divided amongst multiple people. In that situation is, they may need to split ownership of those minerals in multiple ways, okay? So, if your client happens to end up, if they are the seller, and they want to reserve all minerals, then right here, you would check box 1, okay? And if they want to reserve or retain any implied rights of ingress or egress, you would check does, okay? If they want a subdivided, if they want to end up, they want to do an undivided interest, it is imperative that you actually don't even complete this form. You need to have an attorney draft one up or take this form and have an attorney edit it and sign off on it, okay? But again, this is only should be used is if your seller is wanting to reserve all, in this situation in my office, all of the mineral estate. They want a portion, yes, you can check box 2 and fill in the stuff, but again, if you make a mistake, it can end up haunting you, okay? So very key in that situation. Now, in regards to the notice of buyer's termination of contract, now you will see this form a lot, okay? And your years, and as you can continue to conduct business, there will be the notice that is going to be required that your buyer determines that they no longer are looking to, proceed with the transaction. There can be a situation that they end up, that they basically are turning around and they decided that, you know what, we no longer want to end up, we no longer want to purchase this property, there may be an issue or whatever, okay? This contract will be utilized. So it provides for the buyer to notify the seller that the contract is terminated pursuant to the following. It's either the buyer's unrestricted right to terminate the contract under the termination option, provided in paragraph 23 of the TREC promulgated contract form. If buyer cannot obtain the buyer approval in accordance with the third-party financing addendum for credit approval, is another exception to the rule. It also provides the buyer to notify the seller that the contract is terminated pursuant to the following: where the property is not going to satisfy the property approval in accordance with the third-party financing addendum, the buyer elects to terminate under paragraph A of the addendum of property subject to mandatory membership in a owner's association, and the buyer elects to terminate under paragraph 7B relating to the seller's disclosure notice. Okay, so with those, that allows me to now bring this over. This is what the form looks like. So this is basically the options that your client can terminate without breaching contract. So for example, like we've always been using, 123 Main Street, Bryan, Texas 77802, and it's going to be between, in this situation, Colton, we'll just say Colton and Travis. Again, you fill in their full names, okay? And what's happening is the buyer notifies the seller that the contract is terminated pursuant to the following. The very first one, which is the one that you will most likely utilize in your session, is basically the options period. Okay, so if you do options, you do inspections, and after inspections you find out that there's structural or foundation or roofing issues, well, as long as you're within your term of your option, you just X box 1 and you fill out this form, have the party sign, and you send it over. Okay, so if they're in their option period and after inspections they find out, whoa, there's just way too much to deal with this, then what happens is they can check box 1 and they can bag out and earnest money be receipted back to the buyer. Now, let me explain something. That is the earnest money. What happens in some situations, okay, guys and gals, is you have to make certain that when you're using the option period, that you are using it properly. Okay, so for example, if you miscount your days and you check box 1, the 2 through 8 may not apply, and your contract is now enforceable. Okay, so again, the easiest way to get out of a contract is during option period. Bullet 2, the buyer cannot obtain buyer approval in accordance with the third-party financing addendum. Okay, if the buyer goes out, Mr. Colton's trying to get financing and ends up financing falls through, and the key point here, at no fault of his own, very important there, if Mr. Colton is putting a contract out and decides he wants to go out and buy a brand new Mercedes just so he looks cool, okay, and that situation that is fault at his own discretion, he did it intentionally, he's not going to be able to get out of the contract, okay? But if he goes and he's done everything and followed everything by the book, and he ends up, third-party financing does not work out, he can X out so long as he X's out within the time frame that is allowed. Okay. The property does not match or does not satisfy the property approval in accordance with the third-party financing addendum to the contract. The buyer has delivered to the seller's lender a written statement that basically stating forth the reasons of the lender's determination. So in that particular situation, that we go over. They have delivered a letter to Travis. You've received a letter from Colton. He has ended up sent it to you. Mr. Grossman, his lender, has said that because of WDI issues, what is WDI? Oh, they would sleeping. Wood destroying insects. If they find out that there's wood destroying insects in the property, and they end up seeing that there was termites or whatever, and nobody is agreeing to fix those issues, then what ends up happening is that the lender may state that the home is not approvable. I know it's a new word, but approvable, if you want to say, or approved by the lender. And since they cannot approve the loan, you have to now give the notice and you can terminate. Okay. Under 4, buyer elects to terminate under paragraph A of the addendum for property subject to mandatory membership of a property owners association. This is basically, they received their HOA documents, they looked at it and was like, yeah, I'm not paying $2,000 a month to be in this HOA. I want it. Okay. But you have to do all of that within the time frames. Number 5, buyer elects to terminate under paragraph 7B of the contract relating to the seller's disclosure notice. They receive seller's or disclosure and they see problems, structural damages or whatever, they can back out under the seller's disclosure. Okay. Under 6, buyer elects to terminate under paragraph 3 of the addendum concerning right to terminate due to the lender's appraisal. Buyer has received a copy of the appraisal to the lender. They've given it to the lender. So in that situation is, if they are purchasing a house, I put a contract in on Mr. Grossman's property for $300,000. I get the appraisal back and it says it's only $290. Me and Mr. Grossman cannot work something out. Then in that situation is I am released of the contract because it did not meet lender's approval for appraisal. Number 7, buyers elect to terminate under paragraph 6D of the contract or 6C on the condominium. Because of timely objectives were not cured at the end of the cured period, they bag out. So if there's title issues and they were not fixed, they can bag out. Okay? And of course, you have other, which is under paragraph number of the contract or the addendum. Now let me tell you, there's not many outs other than the ones that are already stated. Okay? I had one guy, he tried to end up one time, he tried to get his client, his buyer, out of a transaction, and he was piecing things. Pursuant to paragraph, line such and such, read first 3 words of this, allows him by adding in paragraph this of the addendum of that, will allow him, if you were to construe these, they would be able to allow them out of the contract. Okay? Not how that works. Okay? You don't get to go in and play lawyer and change things. Okay? It has to be specifically stated, word for word, verbatim, and it has to allow the out. Okay? So, again, this is the way for the client to get out of the contract. Okay? All right. Now, there is what's called a mutual termination of the contract. Sometimes the buyer and the seller agree that they both want to just terminate the contract and agree on how the earnest money will be distributed. Most title companies will have a form that's available for the mutual termination. TAR also has a form. The termination of the obligation under the contract are one issue. The release of the earnest money is going to be a separate issue. So, while they do, and I will come back over here to show you, while you will notice here, move, I keep grabbing that wrong thing every time. Move that back over here. You notice right here, there are 2 spots in regards to the buyer's termination. Okay, there is the buyer's termination of contract, and there is the notice of seller's termination of contract. Okay, both parties can terminate the contract. Both parties are welcome to terminate the contract. However, if they mutually decide to terminate the contract, it is in best practices, or at least in my office, it's best practices, if the parties mutually agree to terminate, then both parties should send to the other party a termination. And check box 8 and say mutual termination. Both of them should send them to each other. Therefore, both parties have been notified and they both agree. Now you will notice on these forms when you're completing this, okay, because a lot of people don't understand this, because remember, it's a separate issue. When you pull up the form, notice right here, down at the bottom, there is no spot for the buyer on the seller's form. Same thing applies on the buyer's form. There's no spot for the buyer or the seller to sign on the buyer's form. So in these situations, understand that you're going to have these different situations overall. But again, you need to understand that if they are going to mutually terminate, you should check the box and put mutual termination by both seller and buyer. And it should be on both forms and they should be sent. Okay, that releases each other. However, that only releases the termination. That does not release, guess what, the earnest money. Okay, just because you terminate a contract does not mean that the buyer gets to walk down to title and say, where's my money? Okay, it's not that simple. All right, they have to make certain that they end up, title must get a release of earnest money. If they fail to get a release of earnest money, title will not relinquish the money. Title will hold on to it until they end up receiving it. Okay, so again, you have to make certain that all parties understand this. Now, what are some other forms that we do utilize by TREC for promulgated forms? Well, we do have the addendum for property that's located seaward of the Gulf Intracoastal Waterway. Okay, now this provides notice according to the National or Natural Resources Code that if a property is in close proximity to a beach fronting the Gulf of Mexico, then the public has an easement to or over the area of any public beach. And state law prohibits any obstructions with the public easement and that structures basically erected area over or on the easement are going to be subject to a lawsuit to remove them. So for example, okay, now I can tell you this already, you're probably, unless you are going to be down in Galveston, you're not going to use this form at all. Very rare. Okay. If you live in Dallas, you probably will never use this form. Okay. If you're in Austin or Houston, you may not use this. But if you're down by the Gulf or the Gulf at all, anywhere on those areas of the Gulf, you will use this form daily probably. Okay. Especially if your house is on the beach. Now, with that being said, I'm not going to pull this form up simply because the fact is we don't use this. We don't use this very often here. But if you do, you need to make certain that you explain to your persons, to your clients in this situation that they cannot go over and end up in that situation and erect a structure that obstructs the public from using the beach. So for example, if Mr. Keith ends up, he buys a house on the beach or over there on the Gulf of Mexico, and he ends up, he doesn't like people walking back and forth, obstructing his view, to the ocean. Well, Mr. Keith decides, I'm going to build a fence that extends all the way out to the ocean. Well, what's going to happen is the state's going to come in and say this needs to be removed. You do not own that access to the beach. So in that situation, the fence must be removed. Now, of course, you can fence in your property, but understand that erosion does happen. And as it erodes, that line, that setback line, could possibly cause that fence to be moved back some more. Okay? So this form here allows access in regards to the situation where we are going to be given those particular areas. Yes, that is correct, Ms. Nobles. That is completely correct. If you're going to be working in Galveston at all, or you're going to be using or working in, what is that, Freeport and all them down there, you will be using that form a lot. Okay?
Is that just for places on, like, in Galveston on the beach?
Correct.
Or would it be just for anything in Galveston?
Only on the beach.
Okay.
So
Only where you're in the way of a public
correct.
beach or whatever.
Correct. If I had a way I could like draw on this whiteboard and they could see online, I would show you. But it basically it comes in. So if your house, literally, you could walk out your backyard and go walk to the beach,
Yeah.
then this form would be used.
Okay.
But if your house is just in Galveston in the mainland,
Yeah.
you're not going to use that because you're not able to obstruct access to the public. Yes.
Yeah.
Okay. So it only applies in regards to the public areas. It's basically it's a notice to tell them, hey, FYI, just want you to know, just because you may live on the beach or your beach may be in your backyard, you still end up, you have no ownership in it.
Yeah.
Okay. So it's just a notice in that particular situation. All right. Now, the next one. Now, this is talking about the coastal area. Okay. And this, of course, is going to provide notice according to the Natural Resources Code that the owner of the property may gain or lose portions of the tract because of changes in the boundary of the state-owned, tidally influenced, submerged lands, and the state law prohibits the use, encumbrance, construction, or placing of any structure in, on, or over state-owned submerged lands. So what this is saying, and these kind of would run together concurrently, is that if you're living on a beach, okay, what happens to water is we see an influx of water from the lakes going into, or the rivers going into the ocean. What happens to the land that's around those things? The water does what? Goes up.
Yeah.
Right? If the water goes up, what happens to, this is the boundary line. So this part right here is the boundary line. The water was out here and then just kind of just waves come up and down. And then all of a sudden, it comes up to here. Guess what happens to this? It moves. Okay? And it's an automatic removal. It's not something that's simply, they have to go through a court process. It automatically moves up. And it could move to a point that it could come up to your house. If it comes up to your house, you have to get out of the house. Okay? That's where eminent domain happens for safety reasons. Okay? So, in those situations, if you're going to be by any coastal area, there is the opportunity that the owner may gain or lose certain tracts of their land. Okay? That's why they tell a lot of people that you have to be very careful. If you're buying a house on the lake, you're not really buying it simply because of the fact is that you want that house. Okay? I mean, you are buying it because you want the house, but it's not for the land. Because the key thing is that you could lose access to it at any time. So a lot of times, it's extremely difficult to get flood insurance on houses that are on the lake. Very difficult, because the fact is that there could be that chance that that house floods, which increases the odds. Okay, so very key in that particular situation too. Now, this one is a very fun one. Okay, and this is basically what we call the addendum for property subjected to the mandatory membership in an HOA or owners association. Okay, so it must be used anytime the property, the subject property, not a condominium, is subject to a membership in an owners association. Okay, so in that situation is if you happen to have a home that's going to end up being included into an HOA, then what happens is you must include this form. Okay, and it is not something that's optional. It's actually something that is mandated. So give me a second and I will pull the form up here. There we go. And pull that over here. So this is what an HOA form looks like. Okay, very key right here, as you can see. Not to be used with condominiums. Okay, it is not for that. It's for a home that is located within an HOA district. Okay, so what you have to do, again, 123 Main Street, okay, the HOA, Grossman HOA, 123-456-7890. That's the phone number. Because I have to put the name and the phone number. Now what happens here is you have different choices. You have choice 1, 2, 3, or 4. If your client knows the HOA and is familiar with the HOA, they may tell you, I don't need nothing. I'm good without it. I don't care. I already know everything about that HOA. However, it's always in best practices to end up having the seller pay within approximately 10 days. Okay? If the reason being here is the seller is the one that is familiar with the area, should be the one that is receiving the information and should forward that to the buyer. The buyer should not have to be obligated to go and find their own information or pay for their own information. Yes, they do need to do due diligence, but in the same situation is it's normally fair that the seller pays for the HOA documents and sends to the buyer. Okay. Again, both parties sign. There is going to be sometimes a fee that may be associated, and so the buyer shall pay any and all association fees or other charges associated with the transfer of the property, and these are going to be most of the time $100. Okay. And again, in this situation, in regards to authorizations, you would want the seller to pay the title company the cost of obtaining any information prior to the title company ordering of that information. Okay, but again, all of this is negotiable. Everything's negotiable. I'm just giving you the normal standard processes. Okay, I've had people before tell me, well, Mr. Nobles, what you're entering in here, you know, I've done that and I submitted it to a client or to another agent, and the agent said, no, we don't agree with that. Do you want to call that agent and tell that agent that they're wrong? No, that's not how this works. Everything is negotiable. Okay. The other agent could. I may send this over, say, for example, to Mr. Jacob. He's an agent. I may send this to him, and he may mark through that 10 days and ask for 20. Or he may mark through it and say 5. You never know. Okay. Everything in here is negotiable. I'm just telling you the normal best practices. Okay. All right. Now, a short sale. Let me explain kind of a concept of what a short sale is. Okay. A short sale is a little bit different. And what I mean in this situation is this. A short sale is, say, for example, that, let's see here, Mr. Darren. Mr. Darren buys a property. He purchases this property, and Mr. Darren goes over, he bought the property, he's ended up, he has moved into it, he's lived in the property for, say, 2 years, and lo and behold, God forbid this happens, he ends up, he loses his job, okay? He can't pay his job, or he can't pay his mortgage anymore. The COVID situation has caused a huge issue, and what ended up happening is now, because of everything else, nobody's buying, so his price, his property, his appraisal has dropped significantly. So now his house that he purchased for $300,000 and he's been paying a mortgage on is now worth $250,000. It's depreciated $50,000. So Mr. Darren is like, what am I going to do? What do I do here? I can't afford the mortgage. I have no home. You know, I just don't know what to do. Okay. He tries to go and gets his lender to let him turn it and give it back. But the lender says, well, you know, you're so kind of in debt on your mortgage. Your mortgage is worth more than what the house is. So even if we give it back, you're still going to be in the hole. So everything just seems out of control for Mr. Darren. He is distraught in this situation. So what happens is, lo and behold, Mr. Stahl, Superman, comes to the rescue to Mr. Darren. And he comes in and he says, Mr. Darren, I have a client, Mr. Grossman, that is interested in purchasing your property at $250,000, which is what the value of the property is. Mr. Dan says, but wait a minute, I owe $300,000. Travis says, I understand that, Mr. Darren, but I've got somebody that will pay $250,000 for your property. Well, I'll accept it, but I want $260,000. And you talk to Mr. Grossman, and Mr. Grossman says, yeah, okay, I'm good with that. Mr. Grossman's good, everybody's good. We'll accept it for $260,000. Now the question in this situation, Mr. Stahl, is can Darren sell his property for less than what he owes on the loan?
Let's see why not.
He can't. He has to pay the loan. Remember, when you sell, it accelerates the note, which means due and payable on every penny. If he sells it for $260,000, he's not going to be able to pay off the $300,000, which means now the lender may not sign off on the processing of the loan of title. So what happens is, this is where it gets fun, Mr. Travis, is you have to do what's called a short sale. And this is a nightmare, but I will tell you, you want to make a ton of money in real estate, you want to be dealing with short sales, even though they're hellacious, you want to deal with them, okay? The reason being, when dealing with a short sale, what occurs here is this situation, is that Mr. Travis is going to have to end up, he's going to have to work with the bank to get the bank, say Mr. Keith is the bank in this hypothetical, Travis has to get Mr. Keith to agree to allow for Mr. Darren to sell the property to Mr. Grossman at a lower amount than what's due on the loan. Now, here's the thing. Mr. Grossman, my question here to you. Do you think most banks are willing to allow you to sell a house lower than what is owed on it?
No,
Why not?
because they lose money.
They lose money. And they know, Mr. Keith knows, Mr. Banker over here, Mr. Keith knows that what happens? If I sell it at $260,000, am I really going to get $40,000 out of Mr. Darren? No. Because now I'm going to have to go sue him and get a judgment against him. That's going to cost more money. It's going to be more of a headache. It's going to be more of a mess. I'd rather just leave Mr. Darren in the house, foreclose on the house, take it from him, and just walk away that way. Okay? But here's the thing. If Mr. Keith forecloses on Darren's property, do you, Mr. Stahl, make any money? No. You don't make a dime. You don't make any money. Okay? So in that situation, when I'm talking to people in these areas and I'm going through this, I try to explain to everybody that understand this. As a real estate agent, not many realtors like to touch what we call short sales. They just won't touch them. If they hear the word short sale, most realtors beeline down the road. Okay? However, there are some people that are what's called short sale specialists, and what they end up doing is they come in, Mr. Stahl in this situation, he comes in, he helps people, but what he does is he charges Mr. Darren up front a fee, okay? He may tell Mr. Darren, my brokerage represents people in your situation. We will fight with your bank to get your house sold. We cannot guarantee that you will end up being 100% complete. However, we will try to get majority of the burden off of you, okay? But in exchange, you're going to pay me X amount of dollars up front for me to go in and work. If I sell the transaction, I go through and we get it to work, I credit you back that money at closing, okay? But if it doesn't close, then you only paid me, say, $500 to try, to an attempt it. Now, you got to be careful here. Okay, you got to be very careful, because a lot of people will be like, well, if we're charging $500, why not charge the whole commission? Why not charge $2,000? Why not charge $3,000? Well, here's the point behind this. You cannot, in any shape or form, charge an unsubstantial fee that would shock the court, if that makes sense. We have to make certain that whatever our fee is, it is going to be a fee that is normal. Okay, that's yes, not going to, as they always say, it's not going to be like, holy heck, you charge $2,000 and the guy's losing his house. You know, normally a few $100s is classified as a fair amount. Okay, so I tell people this all the time is it depends upon the amount that you're looking at. Okay, it can end up in some situations. It can be more. It could end up being less. But ultimately, it needs to be of a fair amount. So it is the addendum. This addendum provides a contingency for a seller who is selling the property at a price that is below the current mortgage balance. Okay, so that's what this form is. And it provides the contingency for the seller to obtain the lien holder's consent and a provision for the refund of the earnest money in the event that the lien holder consent is not obtained. So, for example, Mr. Travis does not want to lose out on a deal. Okay, he wants to get in here, get the deal done, and move down the road. Right? But the same situation is that it's good for you in that situation, Mr. Travis, that you can get it, but it also puts Darren at a spot that if he gets somebody to come in with a full price offer of $300,000 on his house, and he's already signed this contract, he cannot easily just bag out. Okay, so in that situation it kind of can be a catch-all, it can be a catch-22 in some situations, but you got to look at the situation from a larger scale perspective. Okay, and so for that being said, let me actually pull up. See if I can't find it. There it is right here. So this is going to be an example of the short sale. Okay, 123 Main Street, and like I said, Bryan, Texas 77802. And as you can see, talks about the contract involves a short sale, blah 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 blah. Seller's requirements, things to that nature. Under here in D, if the seller does not notify buyer that seller has obtained lien holder's consent and agreement on or before, and in this situation, we could say March 1st. And again, you always want to shoot out a long time because getting lenders to work with you is going to be very difficult, especially on something like this. So you shoot out March 1st, and this contract terminates, and the earnest money is refunded back to the buyer. Okay. Again, both clients sign, it provides the notices, and all this basically is stating is that the seller, and here's the key thing, the seller is supposed to go get agreement. But let me say this. Do you think, Travis, that the seller, so Mr. Darren in this situation that we're playing out here, Mr. Darren has not been paying his mortgage, okay? Do you think that Mr. Darren wants to go over and call his mortgage company that he's not been paying?
Nope.
No. Okay. Mr. Darren does not want to have nothing to do with him. So while it says that the seller must obtain the information, who do you think most likely is going to have to obtain it? Most of the time, it's going to have to be the buyer's agent. Okay. And so what happens is if that seller is not represented by an agent, the buyer's agent needs to have the seller complete a release of mortgage information to the buyer's agent, and also a form to release and discuss information with the mortgage or with the company. Now, I can tell you this for a fact. Okay, I can tell you this for a fact. Some mortgage companies, even if you have a written consent that's wrote by law and it's in a deed or a power of attorney and all of that, it's all wrote out and it's certified and everything, you send it to a mortgage company and they receive that paperwork, they still won't talk to you. Okay, I've had that happen before. They still won't talk to you. You have everything done. You sent them everything, verifications, the seller signed off on everything, and the mortgage company still says, no, Mr. Travis, I will not talk to you about Mr. McLean's property. you will need to ask Mr. McLean to contact us. If that happens, and Mr. Darren says, nope, I'm not calling them, then in that particular situation, most likely that transaction is going to be dead on its face. Okay, I've dealt with that before. Did everything I could. Seller refused. Seller was too embarrassed. Did not want to talk to him. Was scared that the mortgage company was going to scream, holler, and cuss like debt collectors do. I had one time I had sat in on a debt collection call with a client, and while we were on the phone with them, they told my client that they were sending the sheriff to the phone number that we were on, and they were going to arrest him and throw him in jail. And my client was freaking out on me, and I interjected into the conversation, and I said, excuse me, but we do not have what's called a debtor's jail here, okay? We don't have that. So I don't know why you're going to arrest him. And then they started talking, well, he breached the contract and blah, blah. And I said, well, he might have breached the contract, but that is a civil matter and not a criminal matter. And then they'll say stuff like, well, he forged stuff, or he fraudulently agreed to this concept, and blah, 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 blah. Okay, my question is, do we want to resolve this or not? That's how you got to be in some of these. So when you get on the phone as an agent, you're going to deal with short sales. Sometimes you have to be very hard. You have to be very demanding when you're on these discussions, okay? It is your job. But I can tell you something. This area right here, this short sale area that we're talking about tonight, I would say probably only 1 in maybe 1,000 agents actually deal with short sales. 1 in 1,000. So what happens there? When the market is dead, most agents would rather jump out of real estate and go to another field than stay in real estate and have to have a few difficult phone conversations. Okay? And like I said, when it comes down to it, money speaks, no matter how much the debt is. Okay? On average, how long does it take to get a lender to agree to this? I've had my shortest one took 6 months. My longest one took me about close to 2.5 years. Okay? But here's the best part about this. Here's the good part. So long as you're negotiating. Okay, now remember, we're still playing this out. Travis is still representing Darren. Travis is still out here. He's representing Darren. He's looking out for Darren's best interest. While Travis is ending up trying to resolve this so that he can make a deal, do you think the lender is still proceeding with eviction of the client? No. Most of the time they won't. Most lenders will put the entire eviction on hold. They'll put the entire eviction on hold while they're seeing if they can't work out an agreement. So you may have saved Mr. Darren 6 months to end up while you're in negotiations. And sometimes, within 6 months, can a person's life change? Can they get a new job or make more money? Yeah. And I will tell you, this is where it can kind of be a catch-22 for you as a person in this field. That's why a lot of agents don't want to deal with it. Travis may end up 6 months into it, and he finally hears back from the lender that, okay, well, we'll agree to the 260 on the 300,000, and you call Mr. Darren and tell Mr. Darren, hey, we got great news. We're going to close. Congratulations. And Darren says, oh, I forgot to call you, by the way. Yeah, I actually got a new job, and I'm making like 3 times what I was making previously, so I'm not looking to sell anymore. And you're going to say, but you're behind 3 months. Oh, yeah, I've already called the bank, and I paid them all up today. So thank you. Appreciate it. You see why some agents charge a fee up front? Because in some situations, the deal may fall through, and you might have spent 6 months back and forth trying to resolve it, and you got $0 out of it. Okay? So again, there can be that situation. But if you're ever going to do short sales, there's a training that I recommend you take so you have an idea in regards to what you're going into. Because some people, like I said, there's always a training for something. But this is one of those trainings that's actually very beneficial, okay, if you go into it. Again, like we continue with short sale, the seller is required to make every reasonable effort to obtain the lien holder's consent. However, option money is still going to be paid to the seller, and of course, time is of the essence, okay? But again, you're not going to put 2 weeks. You're not going to put 3 weeks. It normally takes 2 to 3 months, and most of the time, it may even be further than that, okay? Now, in regards to resale certificates, when we're talking about resale certificates, what we need to end up doing in this particular situation with resale, this is when there's going to be a house that's going to be sold to another individual, okay? So, for example, if we're going into a HOA, what we're going to end up doing in this particular situation is there has to be notice. So like it said, under a resale certificate, the forms are going to be the subdivision information, including the resale certificate for property subject to mandatory membership in a property owners association, okay? In regards to a condominium, so the first bullet deals with a house, the second bullet deals with a condominium, okay? And this form has to be filled out by a representative of the HOA. You, as an agent, cannot complete the resale certificate. The only form you're going to fill out to get the resale certificate is going to be this form here. When you complete this form here, and remember that we put at the top, Grossman HOA 1, 2, 3, 4, 5, 6, 7, 8, 9, 0, that's their stuff. When we submit that to title or the listing agent will contact the HOA and ask the HOA to complete the subdivision information, including resale certificate for property subject to mandatory membership in a property owner's HOA. If it's a condominium, of course, they have to fill out the condominium resale certificate, okay? So it's used when the property is going to be subject to mandatory membership in an HOA, and the buyer wants more information about membership and subdivision information. There are in some situations and in some times that a party may end up, no joke here, there is in some times that a party may end up, they go over and guess what ends up happening? The party ends up, they like the house, they put in the information, and lo and behold, the agent who listed the property did not fill in the HOA information correctly. Had somebody before, they ended up, they put $250, and then when they checked the payment method, instead of putting monthly, they put yearly. So my client went and looked at the property and was like, oh, hell yeah, $250 a year for HOA, and I get a pool, and I get a golf course, and I get this, and I get this, and this. Heck yeah. And they put a contract in, and they're all ecstatic, and they get to the HOA, they get the resale certificate, and the resale certificate says that you got to pay $250 a month, and that's the basic services. If you want access to the pool, and you want access to this, and you want access to that, that's another $250. So it's $500 a month to have access to all of these things. Well, that's kind of important to a buyer, okay? Because that goes on top of the payment that they are paying each month, okay? So when going through these situations, it's imperative that your client be aware. So a resale certificate just gives a breakdown in regards to what are the costs, what amenities are included, what exactly are we all dealing with, what are we including here. It gives the information for the client to have a better idea, a better advantage of knowing exactly what they are receiving in exchange for their monies, okay? So I want to show just briefly that form real quick here. Again, it looks like this. Again, you would fill in the street address, and again, it is prepared by the association. It will talk about is the property or is not going to have a first right of refusal. What is their regular assessment of the property? So what is the current assessment? What are they given? Is there any special assessments, or are there any total of the amounts of unpaid or due amounts that are attributed to the property? Are there any capital expenditures, any reserves, any judgments against the association? It basically is a ton of information that's provided to the lender, to the buyer, to tell them, number one, is this HOA, is it solvent? Does this HOA actually have the funds to continue to operate? And one other thing is, it's very key in here, is it tells the title company, has Mr. Stahl, who's been living in that property, has he been paying his HOAs? Has he been paying his dues? Guys, by the way, just FYI, a lot of people didn't know this, but if Mr. Stahl is not paying his payments every single week, or every single month, I'm sorry, the HOA can force the sale of your home. The HOA can force the sale of your home. So in some situations, a person will actually put their property up for sale because of the fact is they have not paid HOA dues, and because they've not paid them, their HOA is about to foreclose on them. So what ends up happening is they sell it. But here's the thing. If Mr. Stahl, if you sell your house because you're non-payment, does that mean that you just get away from it?
Oh yeah.
No. No. If you owed the Grossman HOA organization over here, say $10,000, you know, yeah. If you owe $10,000 to Mr. Grossman, do you want your money? Or are you gonna let him just skip free and pay nothing? No, he wants his money. So what happens is Mr. Grossman will end up putting a lien against the property to make certain that they do get their funds. But if the tax man comes in and sells Mr. Travis's stuff, then whoever purchases the new property now gets to pay those HOA fees. And that's the reason we had this resale certificate, because whoever purchases it now gets to pay it. Okay? So it's imperative in that situation that you be able to know that. And that's why when you get this information, it's not something to just throw to the wayside. You need to let your client know it. I had one time, we were selling a property, and as we were selling a property, my client did not disclose to me that they had, like 6 years ago, there was an assessment, a special assessment that was taxed on all properties in the HOA, and he never paid his. Well, for some reason, this HOA was extremely tiny. They had, I think, one person at worked probably once a year. And when we did our closing, there was like a ton of money that was owed to the HOA. And we're like, wait a minute, what the heck is this? Well, what happens is not all HOAs are up to date. Okay? And so what happened was this HOA put a ton of interest and late fees and all of this onto his amount, and it ended up, it was like almost quadruple the amount that he owed. But again, my client, as we were going through this, my client had an option to pay it or terminate the contract, and my client had no choice. They're at closing, they had to pay for it. Okay? Again, your stuff that you're receiving as an agent, you need to go through it, read it, make certain you understand it, because it is your obligation to notify your client of the matters. Okay? Now, in regards to the consumer information form, okay, in this form, this is basically, again, a non-contract form. And I want to try to pull it up if I can find it real quick. Give me just a second. Let's see. Of course, trying to find it is not going to be easy when you need it. Yeah. Here we go.
I believe in you.
Got it right here. So, a consumer information form, of course, as it says up here, is brokers and inspectors are required to display this form in their office. The consumers are advised by the availability of a recovery fund and how to contact TREC if they have a complaint. Okay, And so what we're going to do is right here is what that form looks like. Well, make it, there we go. So as we can see, this form must be placed in an area that is visible to anybody that's coming into the office. Okay. Now, if you do not have a physical office, and this is where it kind of is a very fine line. Okay. Say, for example, that we say that Colton he lives in McAllen, Texas. Okay. He doesn't ever come to the real estate office because he lives in McAllen, and he ends up, he basically works from his house. Okay. Because he works so far away, he has an obligation to include this form right here on the board in all of his correspondence with clients. Okay. And as you can see up here, it states, the Texas Real Estate Commission, TREC, regulates real estate brokers and sales agents, real estate inspectors, home warranty companies, easement and right-of-way agents, and timeshare interest providers. You can find out more information and check the status of any license holder at www.trec.texas.gov. You can send a complaint against a license holder to TREC. A complaint form is available on TREC's website. TREC also administers 2 recovery funds, which may be used to satisfy a civil judgment against a broker, sales agent, real estate inspector, or easement or right-of-way agent if certain requirements are met. Now I'm going to stop there for a minute. Very interesting here, because a lot of agents think that just because I am under a broker, I have liability protection, 100%. But Mr. Spall, what does this say, this word right here? What's those 2 words?
Sales agent.
And who would that might be? That might be the individuals that are sitting in this class they're about to become, right? They're about to become a sales agent. So what that means is just because you're sponsored by your broker does not mean that you are 100% released of liability. A lot of agents think, well, I'm sponsored by my broker, so I can go out and be neglectful. I can do intentional things. I can cause problems or whatever because it's on my broker, not on me. I don't have to worry about it. It's not my obligation. Okay? But the key thing is that you want to make certain that as you are doing this, you're completing this form, you need to make certain that you understand that you yourself as an agent could be sued. And when they normally sue, guess how they write the contracts? It is, we are suing Nobles Realty Group, Travis Stahl, and any and all other individuals that are related to this transaction. Okay? So in that particular situation they're going to sue not only just Justin Nobles, but they're going to sue the agent and they're going to sue anybody else that's involved. Sometimes even the real estate inspector can be involved in it. There can be a lot of different things in these situations. So it is very, very important that you understand when you're going through these that it is your obligation. It is your obligation to make certain that you understand that you yourself can be involved in a transaction. And you could possibly be involved in a lawsuit. Now, Travis, I'm going to ask you this question. We talked a bunch about lawsuits. A lot of people probably are thinking, well, shoot, I better not get in this industry because I don't want to ever get sued. Well, can you get sued for driving and having an accident? Can you get sued for having to just walk down and may end up bump somebody or hit somebody wrong and they sue you?
Yeah.
Can you get sued almost for about anything?
Yeah.
Yeah, so should you really give up a career just because of the fear of being sued?
No.
No, not at all. A lot of my students a lot of times be like, oh my God, I need to get out of this industry because I want to get sued. No, You get sued for anything. Get behind your wheel of your vehicle and be driving down the road, you get sued. Okay? The key thing,
Also, this class is basically protecting you against a small percentage of a-holes out there who will do something. But for the most part, people are pretty chill and it's pretty easy just to
work it out.
Work it out just by talking to each other. So.
Yeah, 90% of the time, disputes can be resolved relatively quickly. And most of the time, you throw a little money their way, they're fine. Okay? But in that situation is if you end up understanding, you want to make certain that you understand from this standpoint that, yes, we're talking about basically, I'm teaching you ways of not to get sued. Okay, that's what I'm doing right now. And teaching you how to pass a test. But in real life, this doesn't really matter too much. Okay? Yes, you need to follow the rules, you need to follow the laws, but it should not stop you from going into a career that you want to make money. It is a career that can be life-changing, but you got to put effort into it. Now, when completing this form, you'll notice here that this is just a notice, okay? So again, as I scroll down here, it says, if you have any questions or issues about the activities of a license holder, the complaint process, or the recovery funds, please visit the website or contact Trek at, and then there's their information. But if you notice on this form, there is no signature line. So here's my question, Mr. Grossman. How in the world can I prove that my client has received this form?
Email.
Well, are you sure? I could send you an email. Does it mean you got it? No? What should you do? If you have no idea, what you should do is when you send over a buyer rep or a listing agreement or whatever, throw a little initial down here on the corner. Because if they have to initial it, what happens? They signed it. They saw it. Okay? But if I send an email to them, it doesn't always mean that they saw it. Because you and I, we all know this. We all been here, done this before. We get emails, and what do we do most of the time? Delete, delete, delete. Okay? Well, that doesn't mean that you didn't send it to me, Mr. Grossman. It just means I never opened it. I never had time to open it. So in that situation is you want to be able to have them initial, okay, in regards to this form here. Okay, and it is a way for them to get it. Now I had a student ask me before, when do I need to send this form to them? My response, every single time you meet with the client, period. If you make it a practice that you send this to every single client all the time, guess what happens? You keep yourself out of trouble. I had one person said, well, I'm not going to send this to anybody. If I send this to somebody, it's telling them how to file a complaint against me. Why in the world would I want to do that? I'm just not going to send it. Then they don't know that there's a what do you call that? Where was it here? A recovery fund. There's no recovery. They won't even know about this. I just won't send it to them.
They sound like a smart guy.
Well, here's your problem. If somebody's upset at you enough, all they have to do is type in Texas Real Estate Governing Agency. And what's going to pop up? Boom, right here. And they may have a complaint because you did something. Well, here's one complaint. But then Trek's going to start investigating, and guess what Trek's going to do? Trek's going to start doing some digging, and then Trek's going to see that you didn't send this form to them. Now there's another thing against you. And we're about to get to the next form. You may not send this other form to them. There's another form, another fee against you. Next thing you know, they're racking up stuff. Okay? I would rather send it to them and have a complaint and them say, well, did they send you this notice? Yes, they did. Okay, well, at least they followed that's protocol. Okay? Because understand, when they start investigating, they're going to investigate. Okay? And that's how it works. That's how it always works. Okay? All right. Now the next form, again, a lot of people don't deal with this form. Okay? They think, well, I don't need to send this form out. I don't need to go in or anything to that situation. So what happens in this particular situation is a lot of agents, they kind of put the consumer protection and this form up here, the information about brokerage services, they kind of put these to the wayside. Yeah, I don't need to send that form to Travis right now. I'm just showing him properties. He ain't gonna have no complaints against me for showing properties. He ain't gonna need to know my broker's information. Yeah, he does. Okay, you failed to provide this form, huge fine. Okay, so the information about brokerage services, it is a voluntary, and this is very key, they will test you this on the exam, it's voluntary in form, but mandatory in content. So what we mean by this, and I'm about to pull one up, I actually had an agent that she liked to make her own little things poofy. Okay, she wanted to have little roses and have little things on her forms. And so wanted to have it a certain way. Okay, so while it is voluntary in the way that you format it, it must be mandatory in content, meaning you need to copy verbatim what's in it, but you can put it in any form that you want. And the key point here is it must be provided at the first substantive discussion in relation to a specific property. So if I get on the phone and Mr. Keith calls me and he starts asking me a lot of questions about my listing, guess what? I have an obligation to send Mr. Keith the information about brokerage services and the consumer protection form. Because the fact is, we're having substantive information. But if say for example, Mr. Colton calls me, Mr. Colton, and says, "Hey, Mr. Nobles, I'm looking to look at, some properties with 4-bed, 3-bath. Can you send me some?" Do I need to send him an IABS? No. When I say IABS, that's what we refer to this form as. Information about brokerage services is referred to as IABS. I do not need to send him the IABS form, okay? Because the fact is, Mr. Colton just is inquiring about information. But if we get to a property and he starts asking me, well, how much are they taking for rent? How much is security deposit? How much is this? How much is that? How much? We are now having substantive dialogue. I now need to give him an IABS form, okay? It's my obligation. You fail to give this to them, you can get in trouble. Now, I will tell you this. A lot of people don't know this, but there is plenty of investigators with TREC, and they do retain the services of people. So, for example, Mr. Jacob, TREC calls Mr. Jacob and says, "Mr. Jacob, I want you to call Miss Linda, okay? I want you to call Miss Linda, and I want you to ask her about 123 Main Street and ask her a bunch of questions about it. And I want you to see, does Miss Linda give you an IABS and a consumer protection?" Mr. Jacob calls Miss Linda, goes in, asks a ton of questions. Miss Linda goes in the situation, and she does not provide an IABS. It is an enforcement action that's going to be taken against her, okay? Because of the fact is that you need to make sure that when you're going into these situations, you need to make certain by all means that these IABS forms are going to be completed fully, okay? So here is an example, real quick. Let me pull one over. This is an IABS form, okay? It basically lists what types of license holders there are, what is the minimum duties that a broker must do. A license holder can represent a party in a real estate transaction for seller or landlord, buyer or tenant, agent for both, as a sub-agent, how to avoid disputes, and the licensee contact information, which is right here. Okay, so for example, if you are working with my company, you would type in Nobles Realty Group. You would include my brokerage license number, my broker email, and my brokerage phone. Okay. However, my name goes as the designated broker, my information for my license, my email, and my phone. Okay. If you happen to have a supervisor, say for example that in an office, say Mr. Stahl, you are a team member. Say that you have started a team and Mr. Grossman is on your team. Well, the licensed supervisor could be Travis Stahl, and his number could be this, and it would be his email, his phone, and then here would be Mr. Grossman's information and his information here, and so forth and so on. Okay. Now the thing is Mr. Stahl, he is not in that particular situation here. Mr. Stahl is still a supervisor. He's not a broker. So Mr. Stahl, you can be a supervisor of Mr. Grossman, even though you are not a broker, because you can be what's called a team lead. So you, in that situation, if you had a team and Mr. Grossman's on it, then in that situation, if they had an issue with Mr. Grossman, they know that Mr. Stahl is the next person in line. If Mr. Stahl can't resolve the issue, who's next? You, me. Okay, I'm next in line. And I'm the individual. Now, of course, the brokerage firm is still going to be under the designated broker. So technically, I have to resolve for the top two. But in that situation it gives kind of a hierarchy, okay, in regards to these situations. Okay, so again, in these situations, when you complete it, your brokerage, not 90% of the time, if you're a new agent, they're not going to they're not going to go in here, and like I said, I would help you through this. We've drafted up. But again, like I said, this was really quickly drafted up. But let me explain something. You should print a couple of these off and take them with you. There was an issue a while back, probably about 3 years ago. I remember Trek was doing a increase in enforcement. They were increasing their enforcement stuff. And what they ended up doing was they were increasing their enforcement. What they ended up doing, Mr. Stahl, was they actually they sent investigators to Bryan College Station. And these investigators literally would go around, find a sign, and call the number and be like, hey, Mr. Stahl, this is John Doe, and I want to see your listing at 123 Main Street. Can you come show me right now? Well, you go, well, sure, I'll be over there in a minute. Floor on over there. We get there, and once you get out the car, I go, so tell me a little bit about this property. Well, they're asking this, square footage, bedroom, blah, blah, blah. Okay, all right. Well, would they consider taking $180,000? At that point, we have now had substantive dialogue, because now I'm asking price. You see the thing here. So now that I'm asking price, now Mr. Stahl, you should say, well, I could ask them, but I need to get this form initialed by you. Because of the fact is this form is mandatory, not optional. It is mandatory. Anytime you have any substantial information or contact, this form has to be completed. I had somebody ask me earlier today that ended up, they said, well, what happens, say that Mr. Darren is an investor, and I deal with Mr. Darren a lot. Do I have to get this form completed by Mr. Darren constantly? Well, here's the rule. Whatever date they put down here, okay, on this point right here, whatever date's there, needs to match the buyer representation agreement or the seller's representation agreement. If this is, say, January 1st, 2021, then it's normally going to be valid for the same length of time as your buyer representation agreement. If your buyer representation agreement is not matching these dates, you need to get a new updated form. Okay, so I cannot have Mr. Darren sign an initial and date this form and it be from, say, 5 years ago. Okay, it has to stay current with your forms. Now, could I, in a situation, if I know that Darren's going to use me for a lot of transactions, could I have Darren sign a 2-year buyer representation agreement? Yeah, I could. And instead of doing it every year, I could just have Darren do it every 2 years. Okay, but normal best practices is you want to do it every year. Okay, just put it first thing in the year. Let's get my forms renewed. Okay, just makes things easy, keeps everybody happy. Okay, Mr. Stahl.
Would you have to take that with you? Like, let's say somebody did call and say, "Hey, can you show me this property, whatever?" And I drive down there right now. Is it fine if they start talking about price to say, like, I can see what I can do? Can I have your email? I need to send you a form, and do it. Like, I'll send you a form as soon as I get back to the office about whatever.
As long as you normally mention the form, you're normally okay.
Okay.
Okay. However, you cannot forget to send the form.
Yeah.
So, for example, if you're like, "Oh crap, I need to send you an IABS, but I don't have it with me." Okay. Can I send it to you when I get back to my office? Because I've got to have this initial. In that particular situation, as long as you actually send it, you should be fine. Okay. Rule of thumb is you're supposed to carry this thing around with you, but we know how real estate works.
Yeah.
Real estate is when you least expect it, that's when a client wants to go look at property. Okay. You may end up, and guys, I've been there before. Had all my stuff in one vehicle, had the information about brokerage services, had it all perfectly in a nice little place in my vehicle. And I happened to be riding with my parents in another one, and they wanted to go see a house. And I was like, "Well, let's swing by there real quick. Let them in, let them look at it." But guess what? I don't have my forms. As long as you have access to it, and you send it to them as quickly as possible, you're fine. But you cannot say, "Let me send it to you next week."
Yeah.
It has to be the same day. Okay? But yes, you do have an obligation. It is best to print these off. However, don't do what one of my clients or my agents had done before. They filled this out, they printed out like, I think it was over 100 of them. They went down to Office Depot, filled out 100 of them, and then they kept it in their vehicle. Okay? The problem, like I said, is Trek is known to do this. Okay? Trek is known in this situation where they will end up, just like with the other ones, they change the forms. So you go print off 100 of these, and guess what happens? If your luck's like mine, once you print them off for 100, guess what happens? They change it the next day.
Yeah.
Okay? So my rule of thumb is print off maybe 5, 10 at max, and just keep them in a folder. Put them in your car. Okay? Or if you're like me, what I've done is I've saved them into my Google Drive, and I've got it as a photo, I've screenshotted it, and if I'm there, what I'll end up doing is if I have it, I'll just forward it over to the person, I'll send a picture of it to them, and while they might not have signed it, okay, they have been given it, if you see what I'm saying. Now, another question that comes up in this situation is this. We kind of talked about this in my annual meeting with my agents. Well, what do we do if I walk over to Mr. Grossman, who's a client that I don't know from Adam, and I walk up and I say, he starts asking a question about price, and I say, "Well, Mr. Grossman, here you go, sir. Here's the information about brokerage services. I need you to initial that for me." And what do you think Mr. Grossman's going to say?
No.
"I ain't signing nothing. I don't know who you are. I ain't signing crap." "Well, sir, I have to, by law, I have to give this to you and have you sign. I ain't signing crap." So in that situation is what you have to do if they refuse to sign, the best practice is ask them to turn over on the back of the form and write, "I refuse to sign this document." And that's it. They don't even have to sign that. They just need to write it. Because what happens is if Trek comes in and asks, what ends up happening here? Trek comes in and asks, well, did you give so-and-so, did you give Mr. Grossman and Mr. Straw, did you give him that information about brokerage services? What you can say is you can say, I did, but he refused, and here's his writing that says he refuses it. You do not write it. It needs to be in his handwriting, okay? Because then in that situation, he can't say he's never received it, okay? Sometimes, not all the time, sending a text message. I could send a text message to Mr. Grossman like I did, and I could say, Mr. Grossman refused to sign, and here's the proof that I sent it to him. Now, is it going to be valid in a court of law? It depends on the court of law that you're in. It really depends, okay? So in that situation, like I said, this is simply one of those areas, okay? And again, when completing this form, if you happen to be working for me or another group, one other thing is that I did not end up doing is you always want to make certain that if it is a brokerage and it is a business brokerage, it needs to end up having the designation. So like in mine, I'm a limited liability corporation. Please make certain that you do that. If you're working for a corporation, make certain in that situation that you delete that and you put corp or stuff like that, but you do need to designate the business, okay? All right. Non-realty items addendum, all right? In regards to the non-realty items addendum here, this is that form that we talked about earlier, and I think we showed it previously. I want to pull it up real quick, but this form is basically what we utilize in regards to if there's going to be items that are personal property. So if there are personal property items that are going to convey with the property, we want to ensure in this situation that we are going to include the non-realty items. So when it is non-real estate items that are being transferred from the seller to the buyer, this is an addendum to use. The buyer, of course, will pay for the items in addition to the sales price, and this assures the lender that the sales price is for real estate only. The property is going to be transferred without warranty, however, okay? So if in a situation there are personal items in the property that need to be conveyed, what will end up happening if I'm taking, say, the refrigerator, say that I want to take the refrigerator with me, I would put in here 123 Main Street. I may put that I'm going to purchase the refrigerator for $250, and I would type in refrigerator. Now, of course, I would want to put, I don't even know a name of a refrigerator, Samson, here we go, Samson refrigerator located in kitchen. And I might even go even a little bit more specific. I may say black Samson refrigerator, okay? You want to kind of be very detailed so that you make certain that they do leave the right refrigerator, especially if there's multiple refrigerators, okay? So again, that is another method in regards to having it transferred, okay? So again, that is how you can transfer non-realty items. In regards to the Texas Real Estate Consumer Notice regarding hazards and deficiencies, this is, again, another notice, okay? And it notifies the consumer of the hazards of improperly installed water heaters, faulty temperature and pressure relief valves, improperly installed or lack of ground fault circuit protection, and the decision to correct the hazard is left up to the parties to the contract, okay? There may be in some situations, and I have seen this before, where an individual thinks that they're a handyman, okay, or a handy woman in some situations. And so they may think, well, I'm a handyman or I'm a handy woman and I know what I'm doing. And so in that situation, you know, I'm pretty much, I know what I'm doing and how to do things, okay? That individual may know exactly how to do certain things, and that is completely fine. But in the same situation is, you need to ensure by all means that the client understands, the buyer understands what they're getting themselves into. Okay, and that's another reason also that you would want to end up having having an inspection done, because the inspection is going to basically, in this situation, the inspection allows for protection in regards to the issues. Okay, so again, this is just a notice that you need to be aware of, and it just basically states, you know, there could be these issues. They need to be remedied if there's an issue, and the parties need to discuss that if there happen to be any improperly installed water heaters and things of that, because it could end up being dangerous. In regards to the addendum of property in a propane gas system service, this is basically a notice to a buyer of a property in a propane gas service area. It's to check with the distributor to determine the costs they will be required to pay and the length of time that they will be required to provide propane gas to their property. Again, a copy of this notice that the distribution systems retailer was required to record the real property records must also be attached. This basically allows the client to be aware of, is there other things, is there other expenses? Because the key goal here is we want to make certain that the clients are aware of these different situations, that they are aware of these different costs and expenses. But again, this is another addendum that you do need to be aware of. All right, now that basically wraps up our lecture for chapter 7. As you will see, tomorrow we will cover chapter 8, which will cover other real estate matters. Again, like I said, we've knocked out majority of the material that we needed. So tomorrow we will go through other real estate matters. And then on Thursday, we will do chapter 9. We will come in on Friday and discuss and actually do a few hypotheticals on Friday. And after that, we will call it a class. So with that being said, let me go ahead and stop recording.